Good morning. Hey, Tyler.
Attorney Mike Baldwin, House Counsel for Ms. Taylor, P 65417, Judge.
She's pleading on 280A. They're dismissing the 660. True?
True.
Is that what you want to do?
Yes, sir.
If you plead guilty here, the possible penalties are up to 500 fines, 93 days jail costs, or all those in 2 points. Do you understand that?
Yes, sir.
You plead to that, I'm going to dismiss the other suspend charge from 2023. Do you understand that?
Yes, sir.
Did you sign, read, and understand and advice of rights? You plead guilty, you'll be giving up all those rights and there will not be a hearing. Do you understand that?
Yes.
To the charge driving on a suspended, and how do you plead? On June 15 of 24, were you operating a motor vehicle in Brownstown on Dixon or King?
Yes, sir.
Was your license suspended?
Yes, sir.
Are you on probation or parole?
No, sir.
Anybody forced you to plead guilty?
No, sir.
Please accept it for that charge. The suspend on 4660 is dismissed. You have a bad habit of not showing up in court. You know that? Write this down when you go home. Not showing in court does not endear you to judges. You understand what I'm saying to you? I don't understand this. You didn't show up on the one case, January 3rd of 24, January 17, July 17. You walked in August 4th, and that was a 24. You graced us with your presence on August 8 of 25, but you left after the warrant was canceled.
I had to go to work. But I still came again Tuesday, and then came back today and missed work again. When I found out about it, I came right in. I didn't know about it. My address is not current on my ID. But I'm taking care of it now.
She has a couple tickets out of Taylor, and then she's gonna get her license back, Judge.
I just had license. I just walked through all this course, paid all this money, 2 years straight. So of course I didn't want to mess him up.
Of course you what?
I didn't want to mess him up. I didn't try to mess him up.
Where do you work?
Alright, so
You make good money.
sometimes, you know, later on,
Where do you work? Which Chrysler plant?
back. Still,
Stop doing this.
yes, sir.
You got it?
Yes,
You
sir.
got it?
Yes.
Good. Anything else?
No, Judge, and I did explain to my client that, old cases don't sit well with judges.
100 fine, anything else, ma'am?
No,
100 fines, 220 costs. 75 victims' rights, $50 justice assessment. That's 444. Attorney fees are 40. Your total's 485 or 90 days. Can you pay that today?
no,
How much can you pay today?
100,
What, and then how much can you pay per week?
50.
All right, I'll do that. $100 down, 50 per week. I'll start that beginning on the 18th of September, okay? No, the 19th. Now, if you need more time, you call the court, we'll go on Zoom. I'll give you an extension, or you can walk in here on or before the due date. I'll be glad to give you an extension. I don't care if we have to do that 87 times, but you can't ignore courts like this. I'm dismissing pursuant to the agreement 2-3-B-144-660. Anything else, counsel?
No, and thank you, Judge.
Good luck to you, ma'am. All right. Are you here handling this? Do you know anything about this case, Lieutenant?
No, Your Honor, I didn't know if I could fill in.
I'm gonna ask you to look at this one while I take another one. Robert Stephen Margonic, 25B-149-143.
Good morning, I guess checking here, you have my body photos.
Your name, sir?
Robert McNally?
So this is gonna be a plea under 771.1, right? And
Yes, sir.
For 3 months?
Yes, sir.
Do you have a probation order? If you plead guilty here, possible penalties are up to 90 days jail, fines 500, costs you all. I'll take it under 771.1. Ordered terms, if you're compliant, the case will be dismissed at the end of 3 months. Do you understand that?
Yes,
Again, did you sign, read, and understand an advice of rights form here today?
I did, sir.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, sir.
All right. To the charge, open house party. How do you plead?
Guilty.
Were you in control of the property at 31441 Marigold in Brownstown on August 3 of 25?
I was, sir.
And was there an open house party with minors consuming alcohol?
Your Honor, if I can ask a few questions, my client. that I think will help out you.
Go ahead.
All right, on that date and time, were you throwing a party for your daughter, some sort of graduation party?
Yes, it was great.
All right, at some point, she had invited some friends, correct?
Correct.
And then at some point, although you were in control of that house, your address got leaked out to other people who showed up at your party uninvited.
Correct.
However, you were still the only adult on the scene, is that correct?
Yes.
And although no one consumed alcohol at your houses, you did not have alcohol there, there were kids on or about your property that unfortunately you were under control of and were not able to maintain the scene until police had arrived.
That's correct.
And then at that point, police had arrived, the party had dissipated, and the matter was concluded.
Yes.
Satisfied, Your Honor?
Were there people consuming alcohol at your party?
No, sir.
And how do we get to a conviction?
Well, at this point, it's an open house, right? The open house that he had people on the property and that he was in control of them. Some of them did appear on his property that had already drank alcohol. He did his best to control the situation. However, they were not able to get the
Did you
matter.
talk to Ms. Foley Carter about this?
I did, Your Honor, and I explained the situation.
Call her in. I mean, if the ordinance somehow allows prosecution on this, then it's a horrible ordinance, I'll tell you that. Somebody comes over unbeknownst to him, I just want to make sure. Ms. Foley Carter, your name? I gotta look at the ordinance again. Let's see, what do we have here?
Quoted in the complaint.
Well, okay, now that I got it open though. Oh,
I'm sorry.
no, that's okay. That's all right. 105-3700. I'm gonna tell you the story I was just told. I was just told that some people came over to his daughter's graduation party. They'd already consumed alcohol. Nobody consumed alcohol at the defendant's property that was a minor. And I don't care if they drank at another location or not, that doesn't make him guilty of open house party, right?
That's true as well, Your Honor. The minors that were PBT stated that they were partying at his house, and at no time did they ever say anything about getting intoxicated
Okay.
house.
So what I have here is a lack of a factual basis, though.
Then, Your Honor, what I would ask is for an adjournment of this matter. There were 3 people who were cited for underage drinking. I want to see if they're going to testify. I don't want to come in and say what they, because
Yeah,
just because they were partying at his house doesn't mean they were drinking there. I think that maybe we can get some ambiguity solidified.
Well, I don't disagree with that. So I'm not taking the plea, just to be sure, just to be clear here, Mr. Wyconic.
Okay.
All right, we need to establish that there's a factual basis, and if somebody's drinking at another residence and then comes over to your house and isn't drinking, the law's not an ass, as my father used to say. That's inappropriate for our system to convict somebody. So I'm going to set a new pretrial date. I already set your bond conditions, I believe, earlier. And I'm going to give you a pretrial date, what, the 24th, Lisa?
Yes, 10 o'clock.
10 a.m.
Unfortunately, if I'm mistaken, 24th is a Friday.
No,
Or I'm sorry, I was thinking October. Unfortunately, I'm not available that day, Your Honor. I'll stay with the case if it makes it helpful, but I would ask that we just get permitted for a crossover date. I'm here to follow me on the 1st. If it's easier for me to stay with the case, I don't mind. But I'm not available on the 20th.
are you here on the 8th?
I'm not here on the 8th, I'm here on the 1st, and I'm here on the 22nd of October. That's, I think, a crossover date for you, but that's
How
a,
about we do it, Lisa? Is there a reason we can't do it on the 1st?
Not your Brownstown day.
What would you suggest that I do here?
Well, Brownstown is here, I'm here that day as well. I mean, I would say we just. set
Let's,
right
why
at
don't you,
8:30.
yeah, you come in at 8:30. Let's do that. Okay? Come in at 8:30. And then we won't interfere with Judge Hess. All right? Thank you both, sir. Go down. Where do you work at?
I work at, for Bell Tire, I'm a supervisor in their warehouse.
How much do you make?
About 65.
You know, I really can't I can't appoint you a lawyer going forward. You're entitled to one on your first hearing. And when the first hearing occurs, if there's a plea, you're entitled to that lawyer. But I can't allow this. I can't find in good conscience that you're indigent either. So you're gonna have to go hire a lawyer. I don't want to make this bigger than it is, but so I'm just gonna keep them. I didn't realize that. So I'm gonna go back to the 24th at 8:30, and you're gonna have to go out and get your own lawyer, or you can represent yourself, whatever you so choose, okay? You understand what I'm saying?
Yes.
Now, yeah, so just can't do anything different than that. Good luck to you, sir. Thank you. Thanks a lot, Mr. Shunky.
Thank you, Judge.
Can I have that file and we'll call that case people against, Taja Sakura Dillard Kirk, 5W711-367. And you've already talked to this individual, correct?
Yes.
Your name, please?
Sakura, Lieutenant.
Give me 1 second, Mr. Gate, Lieutenant.
Sure.
All right, Mr. Gate, your appearance.
Matthew Gaten, on behalf of Mr. Builder.
Lieutenant,
Lieutenant Dollar, Whittier Police Department.
so this is an aggravated domestic violence. And the allegation is she assaulted the Letisa Jordan, with whom she had a dating relationship and inflicted serious or aggravated injury. Does she stand me away formal rating?
Yes.
Not guilty, pleas entered. I'm going to address bond. Can you tell me a little bit about what you would, well, first of all, you tell me what you would like to say, and then I will determine whether or not she's been printed. Go ahead.
We're asking for a personal bond on this matter. The alleged victim here, Judge, has a number of mental health issues, namely schizophrenia. She's, the parties have lived together for quite a long time. The injuries that were sustained, or alleged injuries here, Judge, were sustained because the victim here tried to jump out the bedroom window and hit her head along the actual frame of the window when she was falling headfirst towards the ground. My client was actually caught her and pushed her back into the room. My client's had no contact with her since, Judge. There's been no allegations that there's been any contact. Judge, she's obviously walked in on this warrant on her own volition, Judge. The reason she didn't come in earlier was because she did become homeless and she was in between residences at the time because she hadn't moved out of the home that she shared with her girlfriend at the time, Judge.
Can you tell me a little bit about what you know?
Basically, what counsel said, it was somewhere that there was a dispute on exactly how the injuries happened, but there were in fact injuries,
What kind?
just head area.
There's some lacerations to the forehead.
You require her to seek medical treatment, the victim?
That I don't know, I was still trying to speak with, Cerny, who was off campus at the time, it was handling the case.
Does the victim live on Carmel Street?
Yes, Your Honor.
You have 2 warrants out for your arrest, young lady. You know that?
Yes, sir, I had to clear of those today. I went to the court and Remilis and had, paid those off and got on payment plans.
All right, here's what I'm doing. Do you want to make any request on bond?
No, Your Honor.
$2,500 personal bond, but listen carefully. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No contact with Letissa Jordan or prosecution witnesses. You're not to enter 25252 Carmel Street in Woodhaven. No firearms, no dangerous weapons. And I'm telling you, don't have any contact or you're going to end up in jail. Do you understand that? You can't call her, write her, see her, have anybody else do any of those things for you or on your behalf. I'll give you a new date. This is going to be on a state docket day. Lisa, what do you have?
Front.
I'm sorry, you cut out.
It's on the
Oh,
front
it's
of
on
the
the
file.
front? One of these days. Okay, September 16th at 9:45, ma'am. September 16th at 9:45.
Judge,
If you want a court-appointed lawyer going forward, you're gonna have to fill out a petition for one. Yes, sir.
Judge, Miss Miller Kurt did inform me earlier that she does have family emergency. Her mother's got a medical situation going on in Florida, and she doesn't have a ticket to fly out tonight. We'd ask the court to allow her to leave the state to deal with her mother's medical situation.
Can leave state to go to Florida, to attend to mother. How's that? And ma'am, how long you think you're gonna be there? No longer than a week?
A month, so like to 3 weeks to 3.5 weeks to a month.
All right, I'm gonna cut her a break and let's let her go in October. So it should be sometime around October 7th. Is that a Tuesday? Yes, it is. Can you be back here by October 7th? Okay. October 7th at 9:45.
Thank you, Judge.
And you're gonna have to fill out a petition, but I want you to know you do have to go over to the Woodhaven Police Department today to be fingerprinted and photographed, okay? So we're gonna give you an order. That's a condition of your bond that you have to go over to Woodhaven today by 1 p.m. Do you understand that?
Yes.
All right, so we'll give you that order down the hall. Fingerprints and photos to be taken by November 10th
By today, Judge?
by 1 p.m. Yes, today.
You said November.
September 10th, jeez. September 10th, sorry about that. So go over there in the next hour and a half, all right? Good luck to you. I wish you well. Go down the hall, get your notice. If you want to fill out a petition for a court-appointed lawyer, you do that. We'll give you the bond sheet, copy of the bond sheet, and copy of the order. Thank you.
All right, let's talk about that. This Brownstown docket had a little bit of everything. Suspended licenses, open house parties, and even an aggravated domestic violence arraignment was Taylor P., who pled guilty to driving on a suspended license. The court dismissed a related charge from 2023 as part of the agreement. Judge reminded her, in no uncertain terms, that not showing up in court does not endear you to judges. He rattled off her missed dates like a roll call: January, July, August, then scolded her for ignoring court notices because her address wasn't up to date. Still, he accepted the plea, hit her with about $485 in fines and costs, and set up a payment plan, $100 down, then $50 per week. His message was clear: he'll give extensions if she asks, but ghosting the court isn't an option. Then came Robert Stephen White, charged with hosting an open house party. His attorney painted a sympathetic picture. A graduation party for his daughter spiraled when uninvited guests showed up, some of whom had already been drinking elsewhere. No minors were caught drinking at his home, but because he was the only adult present, he was charged under the ordinance. The judge wasn't sold. He pressed the prosecutor for a factual basis, pointing out that if kids showed up intoxicated but didn't drink at White's house, that doesn't fit the statute. He even quoted his father, "The law is not an ass." In the end, he refused to accept the plea and reset the case, telling White to get his own lawyer since he wasn't indigent. It was a mix of fairness and dry humor, with the judge clearly unwilling to convict someone without a solid basis. Finally, there was Tasia Sakura Dillard, arraigned on aggravated domestic violence. The allegation was that she assaulted her girlfriend, Letitia Jordan, causing serious injury. The defense argued the injuries actually came when Jordan tried to jump out a window, hitting her head, and that Dillard even pushed her back inside to prevent worse harm. Dillard had turned herself in and already cleared 2 old warrants. The judge set a $2,500 personal bond with strict conditions: no contact with the complainant, no weapons, and a stay-away order from the residence. Then, in a surprising bit of leniency, He allowed her to travel to Florida for up to 3 weeks to attend to her mother's medical issues, so long as she got fingerprinted and photographed by the police that same day. The courtroom atmosphere swung between stern reminders and pragmatic fairness. One defendant left with a payment plan and a warning, another with a reprieve because the facts didn't line up, and a third with bond conditions that balanced seriousness with compassion. Time to break this one down. Judge handled 3 very different cases with the same approach. No nonsense accountability, a sharp eye for facts, and just enough flexibility to keep things fair. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.